Well, welcome everybody back to World Arbitration Update here in The Hague. Today's May 28th, 2026, and we have the pleasure of our second session of the day following Jose Antonio's explanation of the structure. We're moving through our memorial brief in the arbitration, or typical textbook approach to investor-state arbitration in starting off on topics related to jurisdiction and admissibility. And just further to Jose Antonio's introduction, in terms of kind of bringing together what clearly are important relations. When we talk about ISDS being somewhat distinct or somewhat separate from public international law, and in particular with regard to the climate change debate, I think we actually had a great ending to the last session, and thanks to our commentators and Freddie for a little bit of optimism that there is perhaps a way to reconcile these potential differences and to find a way forward. And I think part of our objective for today, of course, is to look at this not just from the academic point of view, which is obviously incredibly important, but from a practitioner's sense of, how will the ICJ advisory opinion and the other judgments and opinions that we've been talking about, how they will actually influence investor-state arbitrations when and if they are brought on these issues. And I think we're all pretty confident that this will be a topic for tribunals and council for the years to come. So there's a very practical interest in understanding the impacts. And certainly our first panel starts off looking from the entry point. And we've titled this panel, I guess appropriately, Getting Through the Door, the Relevance and Use of Climate Obligations in investor-state arbitration. So in other words, the typical requirements that we see to establish jurisdiction and admissibility, ratione temporis, ratione materiae, and other requirements have been explored obviously extensively through the practice of investor-state arbitration in the last 25 years. And much of that is certainly applicable to our topic today. And so we're going to drill down into some of those issues. For instance, the jurisprudential value of ICJ in international court opinions, the timing issue, ratione temporis, standing, the question of broader participation, and if we can get to it after those discussions, perhaps a discussion of 31(3)(c) of the Vienna Convention. So we have a number of topics that we're going to attempt to address, but let me first introduce our panelists, a brief introduction, and our presenter, and then we'll have, in terms of the structure of this session, a presentation to kind of introduce this particular topic, and then we'll get into further discussions and views on elements of this topic. So to my two over to the left is Dr. Reza Eftekhar. He was introduced earlier. Reza is a senior legal advisor at the Eran U.S. Claims Tribunal. Clearly, in this capacity, he deals with public international law and contractual interstate arbitrations. He's also been a practitioner in international investment and commercial arbitration. He's written widely on commercial and treaty arbitration topics, His most recent book, The Role of Domestic Law of the Host State in Determining the Jurisdiction Ratione Materiae of Investment Treaty Tribunals. That's his recent Brill publication from 2021. He also holds a PhD from Leiden here in The Hague in international dispute resolution. And then to Reza's left is John Laird, who is a counsel also at Crowell and Mooring, but he's in London, I'm in Washington, and we're not related in any way. John is a graduate of Oxford and has his master's from the American University College of Law in Washington, D.C. He's an English solicitor advocate and called to the New York Bar. He has also written extensively and lectured on investor-state arbitration and international law. And thanks for being here as well, John. To my immediate right is Eran Sthoeger, and he is a public international law practitioner and a lecturer in international environmental law at Columbia University presently. He's based in New York, called to the New York Bar, and he's also lectured at numerous other law schools, including Brooklyn Law School and Seton Hall Law School. And notably for our discussions today, he represented Timor-Leste in the advisory proceedings before ITLOS and the ICJ. So thank you for being here. And then to his right is Dr. Margaretha Wewerinke Singh. She is an associate professor of sustainability law and co-founder of Climate Institute 7, all caps, 7, at the University of Amsterdam. She's also an adjunct professor at the University of Fiji and a member of the Permanent Court of Arbitration. She's served as lead counsel for Vanuatu in the ICJ advisory proceedings on climate change as well, and regularly advises and represents states and intergovernmental organizations in international legal processes. So let me now introduce our presenter. We have the privilege here of having today Monica Feria-Tinta. And Monica, as you may know well, is a London barrister, although she hails from Peru and has, I think, the honor of being one of the few, if only, Latin American barristers in London. She's won all sorts of awards last year, I see from her bio. I think the AI was very generous when it put all that in. But she's also worked on many interesting cases. The Torres Strait Islanders case in 2022, the Enrique Alexi incident case, and she's worked on cases concerning the right of nature. She has a recent book titled A Barrister for the Earth, 10 Cases of Hope for Our Future, and that's 2025. And this book sets out 10 of her most interesting cases, and certainly highly recommend that. It's been apparently shortlisted for Best Political Book at the Westminster Book Awards. So congratulations on the nomination, and hope that that will be a success for you. So I could continue on, but it's an incredible pleasure to have Monica here. She's going to spend a few minutes kicking us off on this very topic, and then we'll dive into the panelists' views and commentary as well. So why don't I pass it over to you, Monica, and we'll put up the slides. I think if that's occurring online, moment, or if we can just wait one moment. I think it's being put up. Do we have to connect?
To what?
Do you have the
slides? No, I sent the slides to you.
I think they're putting them up.
I think it's better.
They're putting them up. Are they putting them up? Oh.
No, I don't want to, because I
Yeah, you have your notes.
I just need to see the slides. So I'm going to try to,
You go.
is it on? No? Can you hear me? No? Now, thank you. I think I'm going to start whilst the slides are put up. I think it's quite important, first of all, to see that the whole topic of the integration, in a way, of climate law with the rest of international law has been an ongoing process. As an advocate, I've been part of that and I've been following that. We have seen that in the context of the Law of the Sea, where a treaty that had not mentioned at all the word climate has been interpreted in a way that now pollution is a term that will be encompassing types of pollution that didn't exist when the treaty was ratified. And that is what is going on currently with international law. So if we could go, please, to the first slide, the first one. So the title of my presentation, and we are talking about the gate here, no? It was mentioned the door, is Climate and Investment Law, is the link jurisdictional? And the main point I want to make this morning is that, in fact, it is not. Can we go to the next slide? So I'm just going to... and I want to start with a quote from the Inter-American Court Advisory Opinion, the Climate Emergency Advisory Opinion, paragraph 163, is the only advisory opinion that referred to investment arbitration in an express manner. And you can see there that it does speak about the tension between these areas of law, and it says this tension is not inherent to the investment regime itself. And I think that is a very important assertion. And later in the quote, you can see, in this sense, it is essential to foster a balance that allows states to adopt legitimate regulatory measures to address the climate crisis without undermining the legal certainty and predictability that international investment agreements seek to provide as essential incentives for foreign direct investment. So this quote is rather important because it is really talking about the harmony or harmonization of substantive law. Now, if we could go to the next, please. Next slide. I'm just going to pause there before going to these specific ways how other law has been incorporated or brought in the sphere or the universe that arbitrators had to decide on. I want to mention specifically the work of the International Law Commission that addressed really issues of conflict when it came to different areas of law. Now, the master key to international law, the principle of systemic integration, has been a very core principle to integrate climate law to the rest of international law. And investment law is not, I would submit, an exception. So some of the key premises that come out of the work of the International Law Commission in this respect are the following. Number one, the conflict resolution and interpretation cannot be distinguished from each other. Number two, by conflict meaning conflict between, let's say, two principles of international law. Number two, international law is understood as a system. So we cannot see international law as perhaps as an area that one area will tell you that you have an obligation and the other one will undo the same obligation. There is a way to reconcile conflict. All international law exists in a systemic relation with other law. Therefore, in interpreting a rule, one ought to look into the normative environment of a treaty. This was the most important submission I made to win against Australia in the Torres Strait Islanders case. And I believe that it is precisely the kind of exercise that one will have to do in order to bring climate obligations into consideration when interpreting an investment treaty. And fourth, a limited jurisdiction does not imply a limitation of the scope of the law applicable in the interpretation and application of the treaty. This basically means that the fact that the jurisdiction of a tribunal is on investment law coming from a specific treaty, that doesn't mean that a investment tribunal cannot look at the normative environment that may be relevant to interpret those rules. Now, the way how traditionally we have seen environmental aspects brought to be relevant in interpreting investment law is in preambular dispositions, in protecting the right to regulate using general exception clauses, and finally in carving out environmental issues from the protections of the investment treaty. Next, please. I want to really focus on the point concerning the systemic relationship with other law, because that is fundamental. So far what I am arguing precisely is that the relevance of climate law is not a jurisdictional problem. It's not a jurisdictional issue. It's rather a matter of interpretation, and therefore you immediately jump to substance. So systemic integration is a principle of treaty interpretation enshrined in Article 31(3)(c) of the Vienna Convention, the Law of the Treaties, which requires consideration of other rules of international law in the course of interpreting a treaty, and often operates as an articulated major premise in the construction of treaties, but its function is nevertheless analogous to that of a master key in a large building. And the underlying premise is that international law, in essence, is a system. Next, please. Now, this is not unknown in the context of investment law, and we may remember clearly the principle in the case of the shrimp case, where the following was said. From the perspective embodied in the preamble of the WTO agreement, the generic term natural resources in Article 20G is not static in its content or reference, but is rather by definition evolutionary. So I guess I'm submitting here that the law evolves, and we have seen an unprecedented example on that when courts have been interpreting different treaties and obligations of states that are necessarily relevant now for the investment obligations as well. Next, please. So before I mention this particular quote, one of the things that perhaps is relevant, important, and it was a defense of Australia when it came to the argument that the ICCPR had to be interpreted in the context of climate obligations, was that, well, these are different states' obligations. But it happened that it was irrelevant for Australia because it was a party for the Paris Agreement and it was a party for the ICCPR. But it may be relevant if we are talking only about an obligation that is treaty-based. But I think at present we have gone well beyond that with the ICJ advisory opinion and with the advisory opinion of the Inter-American Court of Human Rights, and also some of the observations of the Tribunal of the Law of the Sea. For example, in the case of the Inter-American Court, it went as far as ascertaining use coherence obligations and really peremptory norms that consisted on climate obligations. And that really gives a very important status to all the obligations that the court had held states had. And by the way, in the context of the Americas, the advisory opinion not only applied to all the Spanish-speaking countries, but it was really, it was really taking into account all the OAS system, which also includes the US and Canada. So it's about the equilibrium that the court also is trying to achieve when it comes to different primary obligations. Next, please. Sorry, it was just the image. So, in other words, what I invite you all is to consider in what way we may be at the very liminal moment that investment law will have to come to terms, just as other areas of law, like law of the sea or human rights, have come to terms with climate obligations. And I think that there is no reason why it should be different. Now, one last point that I like to make is the fact that international law is not centralized, and international law, there's no a doctrine of precedent. And at points, there has been a major shift from other decisions on certain areas. I mean, we have seen the example with the European Court of Human Rights when it came to jurisdictional issues in the case of the recent climate law cases, where they decided that the Bankovich test, for example, was no longer good law. So this can happen. And the reason why I'm mentioning this is because when doing investment law, and I am sometimes also sitting as an arbitrator, when parties plead different case law from before, and there has been some solutions given to conflicts, there is obviously an interest to have consistency when adjudicating cases, but at the same time, there are sometimes moments where something may become bad law as such. And so that will be possibly something open as well when considering whether perhaps decisions in the past were not considering the law as the law has developed today. And well, yeah, with that, I think I will let my colleagues comment. I think there are very specific points that are going to be developed, but I think the point on systemic integration for me is fundamental to understand, so that it's not seen as a gateway, but rather necessarily as something that has to be engaged with already in the merits. Thanks.
Well, thanks very much, Monica. That was a great start off to help frame our discussion. Certainly, it highlights the importance of our next panel, which will be dealing with the obligations, but specifically, and you know, in investor-state arbitration, certainly even in my experience, the questions of, and we now call it systemic integration, but you know, as it relates to Article 31.3c, the role that international law plays when we're interpreting treaties has, you know, certainly arisen in many investor-state arbitrations. Certainly in my early practice with NAFTA Chapter 11 arbitrations, you saw a number of different cases where the NAFTA parties grappled with issues as to, you know, what was the law, in fact, that they were applying. And we'll likely hear more about this next session, but the whole debate around whether fair and equitable treatment was a customary international law standard rooted in a 1926 Mexican Claims Commission case called NIR, or whether it was a form of lex specialis and was part of the evolution and development of international law in the period between 1926 and the 1990s. We saw a Free Trade Commission interpretation on that very issue. And incidentally, buried in that interpretation was a clause which really was addressing 31.3c, in that it prohibited the NAFTA parties from looking to other treaties in their interpretation of the NAFTA. And part of that goes back, and this is really getting down into the weeds, was a case called Methanex, where they were citing WTO treaties and decisions on environmental issues, incidentally, to support what was very much an environmental case concerning toxins that were found in the gasoline in California. And, you know, just on a broader note, just talking about those NAFTA cases, we did see a lot of environmental issues come to the fore. You know, this is 25, 30 years ago now, but one of the early cases I worked on, the Myers v. Canada case, concerned hazardous waste being transported and destroyed over borders. And at the end of the day, it just turned out to be an incredibly political case, very national treatment oriented, favoring Canadians, but as the case turned out, was not really very much related to environmental issues, although it was highly briefed and became very contentious on those issues. It was really very simply a discrimination case. And you can see that there's always this danger, as Freddie noted earlier, of the pretext of the environment being used to justify other motivations. I wanted to go, and you know, Monica has kind of tipped us off to a few interesting topics, but I think one of them, and this is a very fundamental question that you know I've been asking, certainly reading the advisory opinion and certainly the other opinions that Monica's talked about, is that there's kind of a declaration that we have customary international law now, and certainly there have been arguments that this customary international law has been developed. It's now been stated to be erga omnes. You know, this is something that, you know, as students of international law, and I know there's a number of students in this room, when we look to the sources of international law, they are, of course, primarily treaties, custom, and general principles, but decisions and advisory opinions play that subsidiary role to help inform the interpretation of international law and international rules. And this has been a tension in the ISDS world, is that we've had these cases like NEAR, and then certainly when customary international law is argued, whether it's on FET or anything else in these types of cases, it ends up being a question of citing other cases. And of course, that's not how you show practice or opinio juris, by simply citing other cases. It's a much more involved process than that. So I wanted to turn first to Eran on my right to help us on this particular topic about the issue of whether the opinions, when they say that they are customary international law, you know, how are we supposed to take that? How are we supposed to digest that as particularly academics, but as practitioners and arbitrators? Because, you know, if you understand it from some commentators, this is an absolutely major impact. And as Freddie said, much more goes to results as opposed to conduct. But please give us your take on this really important issue.
Thank you, Ian, and thank you, Jose Antonio, for inviting me to be here on this very interesting topic. And piggybacking off your introduction to what I'm going to discuss, the opinions are, of course, very important. They're going to be very influential. We heard about that in the first discussion, and anything I say doesn't take away from that. Obviously, what the ICJ says, generally speaking, is very authoritative or considered authoritative. What ITLOS says about the law of the sea, the Inter-American Court in the context of human rights in the Americas, all of those things are very important. These are very influential bodies. They're very authoritative, generally speaking. But we do have to exercise caution. And so I'm going to use a few examples from the recent General Assembly resolution to give a few examples where it's unclear if what we have is either customary international law, in the opinions customary international law, or the accepted interpretation of some of the treaties. And so caution is due. It should also be said that the opinions differ from each other. They're not identical in terms of what the law is. So Monica just mentioned the Inter-American Court identified climate obligations as jus cogens obligations. That, of course, is not found in the ITLOS or ICJ opinions, and in my view, without basis, but in any event, it's one big difference in the opinions. There are also important nuances. So, for example, about the 1.5 target. So while the ICJ identified the global 1.5 target as a legal obligation that states need to meet, ITLOS did not identify it as a legal obligation. It's one of the factors that goes into assessing whether states are doing enough to protect or reduce pollution to the marine environment. And this is a very important difference. The same goes for the assessment of the relevance of COP decisions. So the ICJ gave them very important legal weight as subsequent agreements. ITLOS did not use the COP agreements to use its conclusion. So these are very important differences in A, identifying customary law, and B, treaty law in terms of interpretation, and that's something to take into account. Now, as Ian correctly said, of course, courts are subsidiary means of understanding what the law is, and states may disagree on the findings of the ICJ, for example, particularly in an advisory opinion. The weight that an advisory opinion ultimately has on crystallizing custom or identifying customary obligations or the correct treaty interpretation, because it's not a binding judgment, ultimately, in my view, depends on the quality of the reasoning and the analysis. And throughout history and advisory opinions, some have reflected what states have come to accept as customary law, and some have been ignored. So it's a mixed bag of reaction. And so it's important to identify states' reactions to these opinions as the most important actors in international law, and whether they agree or disagree over time. And of course, we're just in the beginning of this process, and things can change and evolve over time. And so for that, I just want to look at a few examples in the recent General Assembly resolution on the advisory opinion of the ICJ to show where states may agree more or agree less. So first of all, of course, General Assembly resolutions are non-binding, and this particular resolution was not unanimous. There are about 50 states that did not vote in favor, whether by voting against, abstaining, or not participating in the vote. So that's about 75% of votes in favor. It's also important to look at the explanations of vote. Those are very fundamental in understanding how states view the legal relevance of these resolutions. So for example, you have New Zealand, Australia, Canada, India, Malaysia, and Timor-Leste in their explanations of vote, explaining that they do not see legal significance in these resolutions. They're of political consequence. In this resolution, it's politically important, and they voted in favor for that reason, but they do not reflect, the resolution does not reflect law, and it's very important to stress that the explanations of vote are far from over. The session will resume on June 4th, and most states have not yet spoken and given their explanation of vote. So it's important to bear that in mind. But looking at the content of the resolution, so there are certain things that are worth noting. So on the one hand, it adopts the ICJ's view that several bodies of law, including customary law on significant transboundary harm, human rights, law of the sea, all apply to climate change, and it's not just the climate treaties, which is something the ICJ rejected, and that's in the resolution. And also almost verbatim, the finding on the relevance of significant transboundary harm. But at the same time, and you see this in the evolution of the negotiations from the first zero draft until what was adopted. For example, the language spelling out the obligations found by the court to be part of the treaty regime regarding the content of NDCs, due diligence, meeting or trying to meet the NDCs, all of these were taken out and do not appear in the final version because states, including states that voted in favor, did not agree on all of these findings in terms of what treaty obligations are. And perhaps, to me, the most significant indication about differences between how states accept the opinion is about the 1.5 target as a legal obligation. So this was in the initial draft, but it was taken out of the part of the resolution where the General Assembly enumerates the court's legal findings, and it was put in a separate operative paragraph has language about transitioning away from fossil fuels that mimics the language of COP28. So the court found this to be a legal obligation, but the way it was put in the final text makes it clear that it's a political aspiration, much like it was in the COP28 document. And so that's a very fundamental difference. And it's also important to remember that the court relied on this language in COP28 as part of the subsequent agreements that affect the interpretation of the treaty, and it viewed the 1.5 target as obligatory. So while we've moved forward, and we heard about that from Sergio, for example, we also, in a way, moved a bit backwards. So this language, which was consensus language in 2023, is now no longer consensus in a General Assembly resolution and only has support of 75% of states. And of course, as we know, there is the Santa Marta process. At the same time, as Sergio pointed out, the opinions were not mentioned at COP, the last COP, at all because of contentious ways of looking at them. So all of this is to say, and I'll end here, is that to simply assert that the advisory opinions reflect customary law or the correct interpretation of treaty law has to be demonstrated by the way we were all taught in law school. You have to look at state practice, opinion juris, and in this case, the way states, mainly states, react to these opinions. And that's going to be an evolving process. We're just in the beginning of that process, but clearly some of the elements found by the ICJ, ITLOS, are more contentious than others. And I think whether it's counsel or whether it's arbitrators have to be cautious in the way they address the findings of the courts.
Well, thanks very much, Eran. That really situates ourselves. You know, this is a debate that's been going on in ISDS for a long time internally as to the precedential value of ISDS cases themselves amongst each other, let alone looking towards the ICJ. That being said, ICJ cases have tended to be well cited. If you do the math in ISDS, I think a lot of that is because there's some very useful decisions through the PCIJ and the ICJ over the years, some landmark decisions which continue to be worth citing. I don't think there's a damages or valuation analysis that doesn't cite Chorzów factory and particularly the articles on state responsibility as well. So public international law certainly plays a major role. Incidentally, though, you know, and this has been a complaint by ISDS people, the love is not reciprocated generally in ICJ cases, but we've heard complaints in other contexts on that front. Let me move on to another topic, and we'll drill down even further into the jurisdictional analysis. And I want to talk a little bit about ratione temporis. Now, the idea of time limitations in investor-state arbitration is one, of course, that is a major concern of the practitioners and arbitrators. One of the first things you always look for when reading a BIT or an FTA provision is, you know, are there time limitations in the treaty? Does it apply to investments made before or simply after coming into force? Which measures apply? Can you apply the treaty to predating measures or only to measures following the treaty coming into force and so forth? And, you know, sometimes they're front-end limitations and other times, you know, 3-year limitations are typical in some treaties from the date of the measure. So there's a lot to deal with on that front and a lot of complications, and certainly public international law through the Articles on State Responsibility have played a very helpful role, particularly with those treaties that have no provisions on this type of issue. But my next question then is to Margaretha on the impact of the advisory opinion. And really, I guess the question is ultimately, you know, when has this customary or international law crystallized? Because when we look at the practicalities of investor-state arbitrations, we have investments that have existed for a long time, measures that have been continued for decades in some cases, certainly conduct that could, be at issue by both investors and states. How are we to look at this issue? And I was wondering if you could dive into that topic for us.
Yes, thank you so much, Ian. To begin with, the advisory opinions, I think it's fair to say, affirm the orthodoxy on ratione temporis. So VCLT, Article 28, RCWA, Article 13, are not in doubt. No state is responsible for an obligation that did not bind it at the time of the act. The ICJ in particular is very careful to state that breaches must be established in concreto with due attention to the temporal scope of the obligation and the conduct of states over time. What the advisory opinion does help with is identifying the obligations as continuing obligations, including the customary obligation. So we can look at breaches through the lens of ICHPR Article 14.2 and Article 15 as continuing wrongful acts or composite acts where that is relevant. The advisory opinions give us most guidance on the content of the primary obligation, but the secondary rules of state responsibility are applicable in full, including on these very specific questions that the ICJ and neither did ITLOS or the International Court addressed explicitly, because of course these were advisory proceedings and not concerned with applying law to specific factual situations. But of course, in investment arbitrations, this is exactly what will be happening, what tribunals will need to do. And so that means then also grappling with the question of conduct, but then also the temporal scope of the relevant obligations. Now, when it comes to the customary obligations that were identified, I think we can discern from the guidance that has been provided that these obligations go a long way back and they are evolving in light of, amongst other factors, knowledge of the harm that the conduct could cause. And then what is also relevant is that actually all tribunals confirmed that the precautionary approach or principle is applicable. So that means that even when the scientific evidence is not doesn't provide certainty, there is an obligation to take precautionary action. And so it's probably at the very first stage when science is still evolving, there is some indication of risk, but it's not yet that clear. That's probably where it's mostly precaution that governs the obligation, and then as scientific knowledge consolidates, we move more towards prevention and then towards this heightened or stringent standard of conduct. So due diligence requiring stringent measures. That is what you get when the science is settled. Now, when was the science settled? I think the orthodox answer would be, well, at least around 1992, when the first IPCC reports were out. The UNFCCC was adopted, which defines climate change in Article 1 as an anthropogenic interference. with the climate system, so it's not by natural causes. So when that is in a treaty that is almost universally ratified, dating back to 1992, it's very hard to say that, well, we weren't so sure yet at the time. But for those concerned with this question, it's worthwhile looking at the expert report submitted by the Republic of Vanuatu in the ICJ advisory proceedings, a report produced by Professor Naomi Oreskes, which establishes that the science was consolidated in the 1960s, and there was knowledge, probably arguably enough to trigger precautionary duties from the 1940s onwards. So it goes back a long time. What does it mean then? For an investment that originated in, say, the 1980s in fossil fuel production, that investment may have been lawful at inception, depending on the circumstances, but the host state's continuing obligation to exercise stringent due diligence over its territory, or at least due diligence evolving to its stringent due diligence. That means that today's regulatory tightening is not the state doing something new, it is the state discharging an obligation that has been crystallizing for decades. And so I would say that is the answer to the legitimate expectations argument. Then just a few notes on responsibility, which also is relevant to the jurisdiction question that we are addressing. So the AOs do 4 things that are particularly relevant to a state respondent's arguments. Confirming that the obligation is customary, and here I think there is room for different views of looking at what the court did in the AO. I think it is very important to realize that the requesting resolution 77-276 was a consensus resolution. The proceedings before the ICJ, they attracted the largest participation of any advisory proceedings to date, and the court's findings were unanimous, also on custom. And when we look at the court's methodology for identifying these customary obligations, then that methodology, I would argue, is also robust, conservative almost, not innovative. The innovation is in the application, but the court's reasoning as such, I think it stands quite firmly. And when it comes to the resolution that was adopted last week in New York, I had the privilege of assisting Vanuatu in the negotiations. Of course, it started with a very ambitious 0 draft resolution that evolved. And when we look at that process of the evolution of this text, what stands out is that consensus was not achieved, of course, but a convergence of still very divergent views was achieved by focusing the text on the dispositive of the opinion. So as it would go, with such a rich opinion, with so many aspects, there's favorite parts of different groups. And so ultimately, it was everybody dropped their wish list almost and said, okay, we can agree on at least confirming what the court itself has identified as the essence of the opinion, which is in the dispositive, unanimously adopted with the agreement of judges who themselves also originate from states with significant emissions. And then looking at the language that was used, very carefully negotiated, many different formulations were floated, but ultimately what the resolution says, it welcomes the opinion of the court is not just taking note, it welcomes it as an authoritative, an authoritative contribution to the clarification of international law. That is quite, that's not disputing the findings of the court. And then on the global stocktake language that is there, what is important is that it is it uses very different phrasing from the other paragraphs that are about obligations. So we have the paragraph, the operative paragraph that sets out the customary obligations, that talks about obligations as identified by the court. The same is true for the Paris Agreement paragraph, obligations identified by the court. So it doesn't mention 1.5 explicitly, but well, the court had said what it said on 1.5, so that's part of these obligations. And then the global stocktake language is not framed in language of compliance or obligations. It's simply urging states to, etc. So it's a political paragraph, and in the negotiations, that is also how it was labeled and understood by everyone. And in that sense, that made it possible to gain widespread support for this text. The stringent due diligence standard is very important also because, as Monica already highlighted, this includes the obligation to regulate private actors, and that obligation is considered to be erga omnes by the court, reminding tribunals that cessation is owed regardless of damage. And then, of course, where damage has occurred, there's a duty to make full reparations. So taken together, this is not just a defensive ammunition, it is also a basis for affirmative counterclaims that perhaps wasn't so clearly in existence before Urbasor plus the AOs. So that's also something that offers a lot to work with in future proceedings. So I'll leave it here and very much look forward to further discussion.
I wanted to ask Monica to comment. I know we've talked a little bit about the General Assembly resolution and those discussions last week, since it's very topical. I know Monica probably has a view on that too.
Yes, I just want to pick up on I think the very important question of the crystallization, what point, and also obviously we know that it is quite critical for assessing whether one could foresee, at what point one could foresee that there was such an obligation. Now, what Margaretha has said is quite interesting, and in fact, it kind of aligns with the German court did in the case of Julia. They had a particular example, a case, and RWE was the party involved. What the court said, despite the fact the case lost at the end, but it lost on the facts, but on the principles, what was interesting to notice was that the court said Germany can be held accountable if you knew of the deleterious effect, and that since 1958 it has been foreseeable to an optimal observer that increasing CO2 emissions would lead to global warming with allegedly associated consequences. So that's the reference to the science. And I guess it would be important to assess and consider what role, if any, the consensus, the scientific consensus will have on all of this. Because if we remember, the ITLOS tribunal approached the whole topic starting really from the science and put the science, the scientific knowledge as a really cornerstone in its analysis. So it was not, from perhaps interpreting what had been said in Paris as primary rules, but it was straightforwardly going to the science. And maybe in the context of investment law, the science may also play a role, because things are also evolving when it comes to science. And one last point on perhaps the earlier intervention. I think that, of course, there's quite a lot of food for thought here. But certainly the fact that we are dealing with customary international law in accordance to what the tribunals have said doesn't mean that at the same time there are not treaty law obligations. So this idea that, you know, if I, as a state, say I don't agree with the findings that liberate me as somehow as an objector of the rule, you know, if any rule has been formed, I don't think that really flies, because then, you know, at least you will have to engage with the rules that applied in treaty law and that have been interpreted in an ad hoc manner by different tribunals that deal with particular treaties. So that is, I think, a matter that you necessarily will have to face. And I invite also everybody to really perhaps engage with the original premises that I was putting forward, which is, you know, are we understanding international law as a system? And what the role of lawyers are in that context, or not. And really, we are at a point where we may have really a very opposing views about what is the law, you know, at present. And simply, some states could say that they don't agree with any of the decisions of any of these tribunals, and you know, acting that way as in a way to kind of say that there is no clarity about the law as a consequence. Thanks.
So let me continue on our trip through the jurisdictional grounds, and I want to ask the next question to Reza, and specifically covering the ratione materiae jurisdiction. And in the context of investor-state arbitration, this usually comes down to the definition of investment. And as many of you know, that has been one of the more contentious issues in ICSID jurisdiction, simply because in the wisdom of the negotiators of the ICSID Convention in 1965, they decided not to define the term investment, despite the name of the center, which was overseeing those disputes and the whole nature of the enterprise. That being said, bilateral investment treaties filled the gap in the interim by providing very detailed definitions of investment. And a typical definition is found in a bit like the Dutch-Argentine bit, which states in its definition section, the term investments, in quotes, shall comprise every kind of assets invested by an investor of one contracting party in the territory of the other contracting party in accordance with the laws and regulations of the latter contracting party. And this, in investor-state arbitration, we call this the legality requirement, and certainly this has become a well-argued ground for seeking the dismissal of the jurisdiction of claims, mainly in the context of corruption, but, you know, could be fraud, could be other, you know, serious misdemeanors in the creation of the investment. It has become one of those typical arguments that are made in investor-state arbitrations. But now that we have you know, the developments that we've been discussing of the customary international law, I wanted to ask Reza to look at the scenario in which we have an investment at the initiation of that investment, which violates a climate change rule of either domestic or international law nature, and, you know, what it would be the effect on such a tribunal, particularly when we have this kind of legality requirement, but even in the case where the treaty doesn't have such a requirement.
Thank you very much, Jan, for the introduction. It's a pleasure to be speaking on the 6th edition of World Arbitration Update. As you mentioned, one of the typical jurisdictional defenses raised by respondent states in investment treaty arbitrations is the legality objection, whereby states allege that in the process of making the investment, the investor has violated the law. And this objection is usually grounded in an express or an implied provision in the pertinent investment treaty, according to which an investor at the initiation of the investment has to comply with the laws of the host state. Now, here I'm specifically considering a scenario where the investor at the time of making the investment has violated a rule of domestic or international law nature. And I'm doing so from the lens of the recent pronouncements and opinions by the ICJ and other international courts and tribunals. But here I have to apologize to you because you kind of reminded us of the title of our panel, which is Getting Through the Door. I'm afraid, given the nature of the discussion is more kicking someone out the door. So it's a jurisdictional objection after all. So the first scenario is where the investor violates the domestic law of the host state, the fundamental domestic law of the host state at the time of making the investment, and that domestic law pertains to climate change. And a case in point in this respect is Kortek versus Kenya. In Kortek versus Kenya, the tribunal concluded that it lacked jurisdiction over an alleged revocation of a mining license. And it came to this conclusion by finding that the mining license at issue had been provided to the investor in the absence of a required environmental impact assessment, and also in violation of the Kenyan regulatory framework on a forest and nature reserve. Therefore, the tribunal found that there was no lawful investment capable of protection under the underlying treaty. So, one could say, by reference to the recent opinions and pronouncements by the ICJ and other international courts and tribunals, that you can see an indication, a great emphasis on preemptive regulation in the realm of climate change. And that will make the illegality objection even more relevant going forward in investor-state arbitration cases. Because states would presumptively possess a broader range of climate change laws that they would allege that the investors have violated in the course of making their investment. But that's probably the easier part of my presentation. The more difficult part is where the investor has violated no fundamental local law in the process of investing, but the consequence of the investor's conduct is the violation of a climate change law rule of international law. And here, an investment treaty tribunal will encounter two problems, and a wise counsel pleading on behalf of an investor would probably raise these 2 points. The first one is a textual point. Counsel could say that the clause reads in accordance with the laws of the host state. Therefore, violation of international law rules do not fall within the substantive scope of the legality requirement. And a strict reading of the clause would probably bolster such an argument. But the bigger problem, and probably the more mind-boggling problem, is whether the investor can violate international law on climate change. Now, to be clear, in the course of the establishment and in the course of the operation of an investment project, an investor could no doubt inflict harm upon the environment. And as the ICJ also mentioned in its advisory opinion, such acts and omissions by private parties, which includes also foreign investors, such acts and omissions are attributable to states. But attribution is not what I'm considering here. The question I'm exploring here is where the conduct of the investor results in the violation of a climate change obligation of the state. Can this violation also operate to the detriment of the investor by activating the exclusionary effect of a legality requirement? And here we have to bear in view that these obligations are not directly invocable against private parties, including foreign investors. And I think the title of the advisory opinion speaks for itself. It says obligations of states. These obligations are not addressed to private parties. So perhaps the answer to the question that I just raised is negative. But bearing this in view, is it still possible to hold an investor who has inflicted harm upon the environment in the process of establishment of the investment? Is it possible to hold him or her accountable for that wrongdoing? And here, I could say, yes, perhaps there are pathways to circumvent the climate change obligation of states by referring to general principles of law as a kind of backdoor. And here I'm specifically thinking of the good faith and international public policy. An investor could say, I'm not directly bound by the climate change obligations of states, but it cannot say that I am exempt from good faith or I'm entirely immune from international public policy. And let's review the two maybe very briefly, starting with good faith. An investor could, at the time of making the investment, misrepresent key data regarding the projected emissions, can falsify documents pertaining to biodiversity impact, and can conceal technical specifications pertaining to water contamination as a result of the functioning of the machinery and equipment utilized in the process of the investment operation. So in all these cases, if the investor has inflicted fundamental harm upon the environment, one could say that the investment has not been made in good faith, and as a result is not a lawful investment that is capable of protection under an investment treaty. And we know that the good faith principle has been successfully applied in many of the investment treaty cases, including Plama versus Bulgaria, in Seychelles versus El Salvador, and also to some extent in Metaltech versus Uzbekistan. The other principle that could be used also as a backdoor is international public policy. Do the pronouncements of the ICJ and other international courts and tribunals rise to the level of international public policy? And I would like to leave the precise answer to this question to my co-panelists who possess a deeper knowledge on international environmental law. But let me just share a few thoughts. And here, my personal opinion is that when the stakes are too high, it is arguable that some principles of international, climate change obligations of states have the potential to enter the realm of international public policy as well. In 2021, there was this case, Milieudefensie versus Shell. And Milieudefensie, if your Dutch is good, I think means environmental protection. A Dutch court was grappling with Articles 2 and 8 of the European Convention on Human Rights. It acknowledged that these obligations are not directly invocable against private parties, but it nevertheless took into account the great interest they embody for human rights and for the society as a whole. And as a result, it took these obligations into account in interpreting the applicable standard of care. And using tort law, it imposed emission reduction obligations on the corporation. So one could say, generally speaking, obligations erga omnes, and specifically speaking, imperative obligations pertaining to climate change law of an international nature have the potential to enter the realm of international public policy. And here I'm thinking specifically of certain core climate change obligations, such as the duty to prevent irreversible and serious harm upon the environment, which could arguably fall within the substantive scope of international public policy. But these are the ones that I discussed are litigation-based solutions to the problem that I just mentioned. One could also think of treaty solutions, but I'm mindful of the time, so I would like to hand over back to you, and maybe we will have time to address that in the second round.
Thanks very much, Reza. The mention of the international public policy realm reminds me of that corruption case, World Duty Free v. Kenya, which, and that tribunal grappled with the factual circumstance in which both parties seemed to readily agree that a bribery occurred. The argument had been made, I think, by claimants that, well, this is just how you do business in Kenya. You know, you need to give $2 million to the president and you'll get your concession. Of course, the tribunal viewed that negatively, applying, you know, the developing international law around corruption, made the case that, well, despite the fact that you may be arguing this is okay in Kenya, this is, and the fact that both parties were involved in this, we are still going to dismiss this case, even though, you know, some would argue with a criminal law mentality that the claimant was the victim. Regardless, the public policy indicates this is just simply unacceptable and that the case would be dismissed. And I can see some analogy carrying over into the climate change realm as well. Monica, did you just want to comment on that?
Yeah, very quick, just jumping in on that. I think Reza has really put forward very interesting points. For example, when it comes to the whole assessment of the impact, we have seen developments in England that are quite important on an oil exploration project that did not take into account Scope 3. The Supreme Court in the UK decided that it was actually part of the impact of the investment, and I wouldn't be surprised that this may be an issue when it comes to, in the future, when it comes to assessing what kind of impact that investment may have on the climate. And on the public policy issue, what is interesting, the point on corruption, the parallel, I think is quite fitting because we have also had in the UK the unprecedented step to actually not to give an award, not to approve an award as coming, well, actually right opposite, to a state that it was against public policy, such award on the basis of corruption. In the case, it was a case involving a Nigerian case. But it could just as well be, yes, if it involves perhaps breaches that are so, I would say, substantive when it comes to environmental law. It could just as well fit in the notion of how, for example, in the UK, we see issues of public policy. So that is a very interesting point in my view.
So with only a few minutes left, and certainly last but not least, I want to go to my colleague, John Laird. And we've had a few interesting issues come up, certainly in recent investment state arbitrations, but even in the topic on this panel concerning, you know, how the advisory opinions and judgments and so forth will perhaps open up some processes in investor-state arbitration that we thought, or at least tribunals have kept pretty closed or pretty tight. And I'm referring to specifically third-party submissions and non-disputing party submissions. In the US, we call them amicus briefs. And the question of counterclaims. And I know there's a recent German case, that Azenda, which is very much on point, an ISDS case concerning the ending of the coal-fired electricity industry, and the tribunal dealt with an NDP submission, and arguments were made, certainly, that, you know, in light of the stringent nature of the issues at stake, that having NDPs was certainly a valuable contribution. I think in the most recent order, the tribunal denied that NDP. But John, why don't you dive into some of these issues and take us home?
Thanks very much, Ian. And thank you very much to you and the rest of the team for the invitation to speak today. So yes, going on from what Reza was saying about getting in the door and whether or not we were in fact going to be closing doors or not. So the last bit that I'd like to discuss is indeed whether or not anything is going on here to change who does get in the door and those people who are in the room, why they are potentially there. And as Ian rightly says, we have an excellent right on the point example in Feria-Tinta against poor old Germany that Freddie was suggesting earlier might be under threat from the ICJ opinion. And that route, I would say, on both topics, the problem that may have been part of the general complaints on ISDS remains at the root of whatever is going on substantively. Structurally, ISDS has been for its entire existence and remains to this day a creature of specific treaties, specific small bilateral or multilateral treaties giving out specific forms of jurisdiction by consent, and then creating structures for those two entities, the state and its investor, to battle out something specific that has been handed out in the treaty text. For the idea of outsiders being in the room at all, for a very long time, that was not really even seen as the point. Back in the day, in 1976, UN Central Arbitration rules, of course, they defaulted to in-camera proceedings unless the parties agreed otherwise. As transparency has gotten more interesting to people, we've ended up with things like the ICSID rules specifically contemplating the idea of third parties showing up. But in Feria-Tinta, we have two POs, one from last year, procedural order number 4, which was given on 17 April 2025, and then procedural order number 8, which is brand new, 25 February 2026. As Ian said, this is right on the point, a policy to alter hydrocarbon use in the case of coal, and to try to deal with ideas of climate obligations, whether or not under international law or just a feeling from Germany that that's what they ought to do. Back last year, a group of academics decided that they wanted to jump in, and we have the Rule 67 of the 2022 ICSID rules put to the test. These academics from the University of Cologne and from Cornell's Law School, living in a fairly similar space of the kinds of expertise that they would show to Professor Sorgens again, the intersection of science and the law. Those last year were allowed to speak by the tribunal on the narrow basis of the climate science and the international environmental laws and standards that were in place at the time leading up to the claimant's investment, that being thought to be something which the parties themselves to the dispute might not know specifically about. The more recent one is literally on point of our primary core discussion point today. And this is another group of academics, again, fronted by Cornell Law School's Transnational Disputes Clinic. And these ones approached to say that they wished to speak to the tribunal on two core issues. One, the policy context of the Coal Phase-Out Act, including Germany's climate mitigation measures under the Federal Climate Action Act. And two, the policy context of the 2010 referendum and AET law in light of Switzerland's climate mitigation duties. I can tell you the second one basically fell out of interest of the tribunal, given that it was Germany that was under attack by the claimant in this case. The claimant came from Switzerland, but it was going after German policy. The first one, though, really to our point today, is that they approached and said that they felt that they were within Arbitration Rule 67.2a, because they would elaborate upon the role played by Germany's mitigation duties under the second Kyoto Protocol commitment period, perhaps, for its compensation scheme, and that they would provide insight into the Act, taking account of the interpretation of international climate law by the ICJ, the July 2025 judgment last year. So they were going to turn up and give their views on what the obligations of Germany were in international law. As we've heard from plenty of people say, what on earth those actually are arising from this judgment has been in itself a matter of some furious debate. But the core response of the tribunal was Germany's here and is perfectly capable of telling us about its policy and how it tried to engage in its policy. Going back to anything that Freddie might have been suggesting earlier about what are your mitigation duties and how are you going to do it, that these academics aren't going to tell me anything that the Germans can't themselves. Equally, when it comes to the international law question, the issue is therefore the parties' counsel to discuss in front of a panel that was presumably selected for the idea that it would have expertise in international law. And so this attempt to show up and talk about international law by complete third parties to the dispute was closed down in its entirety. Going back to the first one, you can see there that the most interesting things that I can see that we would still end up having people show up to discuss international climate law obligations in investment treaty disputes about this arising from things like the advisory opinion last year would still have to be anchored in some kind of external expertise on an issue like scientific knowledge of some kind or something about the environment within the country itself and how things were working there on the ground in some way. Not law, not what are the obligations, but in some way trying to inform the tribunal about surrounding facts that the tribunal thinks that neither of the parties who have a right to be in the room already are necessarily going to be able to tell them themselves. So that's that. I don't think that we are going to be able to thereby see the investment disputes which still involve climate law having a lot more people get in the room than in the same circumstances that we've had from previous cases before, most particularly when we've been dealing with things like whether or not a gold mine has been causing serious environmental damage and how it's been affecting the local culture and environment. That a third party, interested party, may be able to actually give interesting information on that neither of the parties have got any chance of doing themselves properly. When it comes to counterclaims, to be extremely brief on it, I would tend to believe that the creativity that Reza has been discussing about blocking a investment from receiving protection by creative interpretations of the definitions of whether or not something is within legal bounds is more likely to be where we can take things here than counterclaims and actually allowing the states to enter the room with a sword as well as a shield. And then again, it goes back to the fundamental structure of what these dispute resolution fora are all about under the literal terms of the treaties as they are written. Our host here today of the Netherlands, in its own model bit from 2019, shows the kinds of careful drafting that makes that sword very unlikely to ever exist. If you look at how it thought that environmental or human rights issues ought to enter the idea of an investment dispute. It's got a very long section on dispute resolution, which is also very explicitly drafted, so that the nature of the claim that can come before the tribunal is a claim brought by the investor. Now, it may involve domestic law and international law and factoring in, but at first root, the explicit jurisdictional basis is written in that manner. And most treaties are written like that. And so I just don't think that we can see a route to bringing blame and seeking a counterclaim in damages as what is likely to happen, even if we were to try to involve aspects of good faith. And even so, as Reza says, private parties aren't necessarily going to be seen as having obligations to take part in. But what they may do, I think, is may become increasingly creatively tried, is to say that they don't have a protected investment because they undermined the state's obligations. I mean, if we particularly look at, again, what hosts wrote as to their definition of scope of application of the model was, this agreement shall apply to an investment made in accordance with the applicable law of the host contracting party at the time the investment is made. And we can see there that there was probably going to be plenty of room for trying to say that when was the investment made was an ongoing process, and as my obligations changed, whether or not it was an investment within scope would change. But would we want to actually be able to have anything that we would try to seek damages from the investor in the course of this? The best that was thought prudent in this model bit was to suggest that the behavior of the investor should be included without prejudice to national, administrative, or criminal law procedure. A tribunal, in deciding the amount of compensation, is expected to take into account non-compliance by the investor with its commitments under the UN Guiding Principles on Business and Human Rights and the OECD guidelines for multinational enterprises. Now, even there, that's something that's been actively thought about, which isn't even really particularly about environmental law. So, as a very brief conclusion on all of that, I don't think any swords are coming into the room, as well as shields, and I think it's unlikely that we have qualitatively changed who else gets to enter the room. Certainly not more lawyers.
Well, thank you very much, John, for tying up some of these loose issues. I know the questions of counterclaims had been raised earlier. I think we're coming to the end of our time, and I think this panel has played a very useful role in addressing this part of the question concerning the impact of the advisory opinions and judgments on ISDS, and as well has teed up a few of the questions we're going to hear, in the next two sessions. And apologies to those moderators and panelists if we took any of your thunder, but I'm sure you're going to get into those issues much more deeply than we were. But let me then take this opportunity on behalf of the organizers and WOW and Jose Antonio and the whole team to thank our panelists and Monica, our presenter, for an excellent panel and continuing our very interesting discussion today, and looking forward to seeing folks who are virtually online back for the next panel, which I believe is scheduled for about an hour and a half from now. But for those of us here, lunch has been arranged, and we will adjourn appropriately for that and return at 1:30, I believe. So thank you again, and let me invite everyone to express their gratitude to our panel.